So here, critically examine the basis, the basic structure. I mean to say, critically examine the basic structure theory, regarding the Indian Constitution. Right? भारतीय संविधान से संबंधित मूल ढांचे के सिद्धांत का, आलोचनात्मक मूल्यांकन कीजिए. ठीक है. क्रिटिकल एग्जामिनेशन ऑफ द बेसिक स्ट्रक्चर थ्योरी रिगार्डिंग द इंडियन कॉन्स्टिट्यूशन. राइट, इसका इंट्रोडक्शन स्टार्ट करते हैं. राइट, मैं जो भी बता रहा हूँ, राइट, ये जो है मैं पर्टिकुलर प्रीवियस ईयर क्वेश्चन पेपर है ये. ठीक है, तो ये जो बीपीएससी के प्रीवियस ईयर क्वेश्चन पेपर होते हैं उसके तहत ही मैं बता रहा हूँ. ठीक है, एक एक क्वेश्चन करके मैं पार्ट बाय पार्ट मैं वीडियोस को अपलोड करूँगा. राइट, सो जो थंबनेल में आप देखे हो वो बिल्कुल सही देखे हो, और उसके अकॉर्डिंग जो है पार्ट बाय पार्ट मैं प्रीवियस ईयर क्वेश्चन पेपर को अपलोड करता रहूँगा. तो पहले हम समझते हैं क्रिटिकली एग्जामिन the basic structure theory regarding the Indian Constitution. ठीक है, so introduction is the basic structure doctrine is a judicial principle that limits the amending power of the Indian Parliament. It ensures that certain fundamental aspects of the Constitution of India cannot be altered even by a constitutional amendment. This doctrine was established by the Supreme Court of India in the landmark case of Keshav Nanda Bharti versus State of Kerala 1973. It serves as a safeguard against arbitrary constitutional amendments that could disrupt the essence of democracy, rule of law and fundamental rights. Right. Background and evolution here. Shankari Prasad case here. Shankari Prasad case 1951. The Supreme Court upheld the power of Parliament to amend any part of the Constitution, including fundamental rights. Okay. Golaknath case 1967. The court ruled that fundamental rights cannot be amended by Parliament. Keshav Nanda Bharti case 1973. The court introduces the basic structure doctrine, starting that while Parliament can amend the Constitution, right, it cannot alter its basic structure. Okay, Indira Gandhi versus Raj Narayan 1975. The Supreme Court reformed the basic structure doctrine, striking down amendments that affect democracy and rule of law. Okay. Minerva Mills case 1980. The court further clarified that the harmony between fundamental rights and directive principles of state policy, that we call DPSP, directive principle of state policy, is a part of basic structure. Vaman Rao case 1981. The doctrine was given retrospective effect from April 24, 1973. So the key features of the basic structure doctrine here, while the Supreme Court has not given an exhaustive list here, certain elements have been recognized as a part of basic structure, including here supremacy of the Constitution here, rule of law, sovereign, socialist, secular, democratic and republic nature of India, judicial review, separation of powers, independence of judiciary, parliamentary system of governance, federalism, unity and integrity of the nation here, welfare state. So the critical analysis, if I'm talking about here, that argument in favor here, protection against authoritarianism. Okay, it prevents here autocratic and dictatorial rule by limiting the power of Parliament to amend core constitutional values, preserves fundamental rights here, prevents Parliament from diluting fundamental rights here, ensuring justice, equality and liberty, maintains constitutional supremacy, ensures that the Constitution remains the fundamental law of the land, and prevents its misuse, judicial safeguard against misuse of powers. Courts can strike down unconstitutional amendments, maintaining constitutional democracy. Balancing power here protects the doctrine of separation of powers, by ensuring that the executive, legislature and judiciary function independently. Okay, so here arguments against undemocratic and judicial overreach. Critics argue that this doctrine gives excessive power of the judiciary, leading to judicial supremacy over the elected Parliament. No constitution mentions the basic structure doctrine is not explicitly mentioned in the Constitution here, making it judicially created doctrine. Ambiguity and subjectivity. The scope of basic structure is not clearly defined here, leading the judicial discretion and unpredictability. Okay, limits parliamentary sovereignty. Okay, some urge that elected here representatives should have the power to amend any part of the Constitution as per the people's amended obstructions to progressive amendments. In here, in certain cases, the doctrine has prevented progressive reforms and constitutional amendments. So the conclusion of the point is, the basic structure doctrine is double-edged sword, right? While it protects democracy, fundamental rights and constitutional values, it also raises concerns about judicial overreach and parliamentary sovereignty. Okay, the doctrine ensures that the essence of the Indian constitution remains intact, right? But at the same time, it requires carefully application to maintain constitutional balance and democratic governance, right? So here, इसको मैं अब हिंदी में बताऊंगा, ठीक है? भारतीय संविधान से संबंधित मूल ढांचे के सिद्धांत का आलोचनात्मक मूल्यांकन। तो यहाँ जो परिचय है इसका पहले बताएं। तो मूल ढांचा सिद्धांत है, बेसिक स्ट्रक्चर डॉक्ट्रिन, भारतीय संविधान की एक महत्वपूर्ण न्यायिक अवधारणा है जो संसद की संशोधन शक्ति को सीमित करती है। यह सिद्धांत यह सुनिश्चित करता है कि संविधान के कुछ बुनियादी तत्वों को संशोधन के माध्यम से बदला नहीं जा सकता। इस सिद्धांत की स्थापना केशवानंद भारती बनाम केरल राज्य 1973 मामले में की गई थी। इसका मुख्य उद्देश्य यह सुनिश्चित करना है कि भारतीय संविधान की लोकतांत्रिक, धर्मनिरपेक्ष और न्यायिक स्वतंत्रता जैसी विशेषताएं बनी रहे, ठीक है? यहाँ पृष्ठभूमि और विकास है। शंकर प्रसाद मामला 1951, संसद को संविधान के किसी भी भाग में संशोधन करने की पूर्ण शक्ति प्राप्त थी। गोलकनाथ मामला 1967, सर्वोच्च न्यायालय ने निर्णय दिया कि मौलिक अधिकारों में संशोधन नहीं किया जा सकता। केशवानंद भारती मामला 1973 है। यह सिद्धांत दिया गया है कि संसद संविधान के संशोधन तो कर सकती है, लेकिन उसके मूल ढांचे को नहीं बदल सकती। इंदिरा गांधी बनाम राजनारायण 1975 की बात है। न्यायालय ने चुनावी लोकतंत्र और न्यायपालिका की स्वतंत्रता को बचाने के लिए इस सिद्धांत को और मजबूत किया। मिनर्वा मिल्स मामला 1980, ठीक है? मौलिक अधिकारों और राजनीति के निर्देशक तत्वों, जिसको हम लोग बोलते हैं डीपीएसपी, के बीच संतुलन को मूल ढांचे का हिस्सा माना गया। वामन राव मामला 1981, इस सिद्धांत को 24 अप्रैल 1973 से लागू करने का निर्णय लिया गया। मूल ढांचा सिद्धांत के प्रमुख तत्व: संविधान के सर्वोच्चता, न्यायिक समीक्षा, लोकतंत्र और गणराज्य प्रणाली, संघवाद, अधिकारों की स्वतंत्रता, न्यायपालिका की स्वतंत्रता, सत्ता का पृथक्करण, दैट वी कॉल द सेपरेशन ऑफ पावर, राज्य की एकता और अखंडता, राइट? सो आलोचनात्मक मूल्यांकन क्या है? कि समर्थन में तर्क, तानाशाही से सुरक्षा। यह सिद्धांत संविधान को तानाशाही शासन से बचाने में मदद करता है। मौलिक अधिकारों की रक्षा, संसद द्वारा मनमाने संशोधन करने व्यक्तिगत स्वतंत्रता को कमजोर नहीं किया जा सकता। संविधान की सर्वोच्चता, यह संविधान को परम विधि बनाए रखता है। संवैधानिक स्थिति, तो यहाँ पे संसद को अनुचित संशोधनों से रोकता है। विरोध में तर्क, लोकतांत्रिक प्रणाली पर अंकुश, यह न्यायपालिका को अत्यधिक शक्ति प्रदान करता है जिससे संसद की संप्रभुता सीमित होती है। संविधान के स्पष्ट उल्लेख नहीं, यह सिद्धांत का संविधान में कोई स्पष्ट आधार नहीं है, यह न्यायालय द्वारा निर्मित है। यह अनिश्चितता और अस्पष्टता, मूल ढांचा की स्पष्ट परिभाषा नहीं दी गई है, जिससे यह न्यायिक विवेकाधीन हो जाता। निष्कर्ष क्या है कि मूल ढांचा सिद्धांत भारतीय संविधान के संरक्षण नीति का एक महत्वपूर्ण हिस्सा है। हालांकि यह बहस की विषय बना रहता है क्योंकि यह न्यायपालिका को अधिक शक्ति देता है और संसद की संशोधन क्षमता को सीमित करता है। यह आवश्यक है कि इस सिद्धांत को संतुलित रूप में लागू किए जाने के लिए, ताकि संविधान की मूल आत्मा बनी रहे और लोकतंत्र भी सुरक्षित रहे। So this is all about that particular, that we called critically examine the basic structure theory regarding the Indian Constitution, right? So here critically describe about the amendment process of the Indian Constitution. भारतीय संविधान की संशोधन प्रक्रिया का आलोचनात्मक वर्णन कीजिए। तो ये क्वेश्चन है बीपीएससी का, ठीक है? The amendment process of the Indian Constitution here, a critical analysis, right? So I will start from the introduction, right? The amendment process of the Indian Constitution is crucial as it ensures that the Constitution remains dynamic and adaptable, while maintaining its fundamental principles. The Article 368 of the Indian Constitution lay down the procedure for amending the Constitution, right? Unlike the rigid Constitution here, example, US Constitution or flexible Constitution, example as UK Constitution, right? India's amendment processes here follows a middle path, making it partially rigid and partially flexible, right? Its process is both a strength and a challenge, and it's allow for constitutional evolution, but also raises concern, regarding potential misuse by ruling government. So basically the point is that, I have actually researched on it, and this is totally based on the previous question paper, right, of BPSC and UPSC. So I'm just trying to elaborate my point of view. And I will say that this is totally for the civil servant examination, whoever actually practicing for it, whoever actually trying to crack the civil service examination, right? So I am just trying to help you guys, and I'm also trying to learn it from this because I'm also an aspirant. So I'm just trying to just go through with the particular previous year question papers, right, of UPSC and BPSC. So just I'll just say like you should go and note it down whatever I'm trying to push myself, I mean, with the questions and the answers, right? So I think you should note it down, right, appropriately, the way I'm trying to address my point of view according to the questions what I have already addressed. So yeah, I know. So this is what I'm trying to say is I will go through one by one video, right? Might be possible that in one video you will get 2 to 3 videos, 2 to 3 points, 2 to 3 questions on which is totally there in a previous year question paper. So if you research, if you start searching the previous year question paper of UPSC or BPSC, you will get it. But now this is the BPSC, Bihar Public Service Commission Civil Services Examination, right? So this question is already it was there. So now I'm basically trying to go through with it. So I will just try to recommend you guys that please note it down in appropriate manner, right? So I have already researched, and in my laptop this is totally there, right? So I don't have any particular what we call where newspapers, where news channels actually we call, actually I have no idea. In the camera there is a particular articles moving around, right? I'm not understanding what's the name of it, but I don't have any options. I have to show the face, right? But now in that way I will try to teach. So please, right, support it. So now the point is that here, method of amending of Indian Constitution. So Article 368 provides for 3 types of amendment, right? Okay, so note it down in an appropriate manner. There's no you can, if you want slower, there's nothing issue, but I don't want to waste your time, right? I know you guys are so well, right, in Hindi and English as well. So I will say like just you have to note it down, or you want to take the pause, or you will try to note it down, because this is totally a previous question paper, and nowadays not even BPSC or UPSC, all the examinations question is totally based on this. So I will say don't try to miss it, right? Okay. So here, amendment by a simple majority of parliament, right? So certain provisions of the constitution can be amended by a simple majority of both house of parliament, so that is more than 50% of members present and voting. So these amendments are not considered constitutional amendments here under Article 368. So examples here, what I have already make my way with the help of Google and a particular ChatGPT and all. So I'm just trying to give you that products which is actually useful for the examination. This kind of stuff is really useful, right? So I don't want to miss myself, I don't want to miss it, and I just want to go through and elaborate my point of view with the particular questions of it. So yeah, if I'm talking about the examples of amendment by a simple majority of a parliament, so here, creation of new states, or alteration of the state boundaries, Article 3 here, rules regarding the use of official language here, Article 344, Article 120, salaries and allowances of MPs, right, Article 108, and Supreme Court and High Court judges, Article 125 and Article 221. So criticisms here, this method makes it easy, to change certain provisions, which can lead a frequent alteration based on political interest, right? So here point 2 is amendment by a special majority of parliament. This method requires requires a 2/3 majority of members present and voting in each house of parliament. No more than 50% of the total strength of each house must approve. So example here, fundamental right here, part 3, okay, directive and principles of state policy, DPSPS, part 4 here, judicial structure and power of Supreme Court and High Court, right? So criticisms here, through stricter than a simple majority, it still allows parliament significant power, raising concerns and majoritarianism, okay, where a ruling party with a strong majority can amend key provisions. Okay, so the point 3 is point 3rd is amendment by a special majority and ratification by half of the state legislature. Okay, so here certain amendments required ratifications by at least 50% of the state legislatures after being passed by a special majority in parliament, right? Examples here, elections of the president here, Article 54 and Article 55 and Article 71 as well, right? So distribution of legislative powers between the center and state, Schedule 7 and Article 245 to 55. Judiciary related provisions such as High Court judiciaries, jurisdiction, I mean to say High Court jurisdiction, judiciary related provisions, such as High Court jurisdiction. Criticisms, if I'm talking about here, through this method here ensures, federalism, state legislature have no power to propose, amendments making the process parliament dominated. Okay, so critical analysis of the amendment process here, strengths of the amendment process here, balances here, rigidity and flexibility. India's amendment procedure here ensures that the constitution is neither too rigid nor too flexible, allowing here necessary changes without frequent alteration. Safeguard federalism in some cases. Some amendments required state ratification, protecting the interest of state, right? Judicial review as a check here. The Supreme Court can invalidate unconstitutional amendments, as seen in Kesavananda Bharti case 1973, preventing misuse by the ruling government. So here allows socio-economic reforms. So key amendments like the first amendment 1951, curbing land reforms challenges, and the 73rd and 74th amendment 1992, local government governance, have helped in nation building. So point 2 is weakness and criticisms of amendment processes. So what is it? No direct role of citizens. So unlike the US here, okay, fine. I have actually a point what I have learned now, that I don't have any teleprompter. That we call the teleprompter. So if I have a teleprompter in future, right? If you guys supporting me, if I will earn, right, then I will firstly buy a teleprompter, right, from my YouTube money. So this is what I want is when I will buy the teleprompter, I will not hesitate, right, at all. When I'm not even hesitating, right, so that teleprompter will help me a lot for this. Okay, so you guys are intellectual, I know you will understand. Okay, no direct role for citizens. Okay, unlike the use here where constitutional amendments required referendums, Indian citizens, okay, have no direct role in amending the constitution. Excessive parliamentary control, most amendments can be made without state approval, making the process heavily centralized and parliament dependent. Okay, so vulnerable to political misuse here. Ruling parties with large majorities can easily pass constitutional amendment to suit their interest. Examples here, 42nd, that we call the 42 amendment, I'm to say. Okay, fine. And 1976 here, increased executive power during the emergency under Indira Gandhi. Right. Okay. 99 amendment here 2014 had created the NJAC for judicial appointment, but was struck down by the Supreme Court. Right. Okay. So weak protection of fundamental right initially, before Kesavananda Bharti case 1973, Parliament could amend fundamental rights, making them vulnerable. Okay. Vulnerable, however the basic structure doctrine now protects them. So here complex and lengthy process of certain amendments. Okay, so some amendments require state ratification, making the process time consuming and difficult in politically divided scenarios. Okay, so here landmark constitutional amendments and their impact. So the conclusion is India's amendment process ensures that the constitution remains relevant and adaptable, but it also has several shortcomings. While it balanced rigidity, flexibility, it is often dominated by parliament and lacks direct citizen participation. Judicial review acts as an essential safeguard, but political misuse remains a concern. Reforms like introducing referendums, enhancing state participation, and reducing arbitrary amendments could strengthen the amendment process further. So this is all about this. So I hope you like it. So here, is reservation for economically weaker section, EWS justified? Is reservation for economically, weaker section EWS justified? So here is the critical analysis, So the introduction, I'm starting from the introduction, right? So reservation in India, has traditionally been provided based on social and educational background, backwardness, right? Focusing on scheduled caste, SC, right here, ST, that we call the scheduled tribes, and other backward classes, obviously. However, in 2019, the 103rd here, Constitutional Amendment Act introduced here 10% reservation for economically weaker section, that we call EWS. EWS is what? EWS is economically weaker section in education and public employment. This was a significant shift, as it provided reservation, based on purely on economic criteria, excludingly, okay, scheduled tribes, scheduled caste here, OBCs, right, all the backward classes here. This move sparked debates on whether economic criteria alone should be a basis of reservation. So the arguments in favor of EWS, right? Reservation addresses economic disparity, unlike your caste-based, a reservation which focuses on social backwardness. EWS reservation targets financially disadvantages, advantaged, sections of society here, ensuring economic upliftment. Okay, upholds the principle of equality. It promotes the constitutional idea of equality here by giving opportunities to poor people, from the general category who were previously excluded from reservation benefits here. Corrects an anomaly in the reservation system here. Earlier they are economically weak individuals from upper caste and had no reservation benefits, right? Leading to economic disparity within the same society, right? The EWS here quota, provides them with a level playing field, right? Reduces the stigma around reservation. Since EWS reservation is based on totally financial condition rather than caste here, it helps reduce the social stigma here associated with reservation, right? Supreme Court's validation here, in Janhit Abhiyan, right, Union of India 2022, the Supreme Court upheld EWS, right, reservation as constitutionally valid, emphasizing the need of economic based on affirmative action here. Okay, arguments, the arguments against EWS reservation here goes against the concept of reservation, right? The original purpose of reservation was to uplift here socially and educationally backward communities, okay, who faced centuries of discrimination. Economic status is temporary, whereas social backwardness is deep rooted and historical. Okay, excludes here SC/ST obviously from EWS benefits here. So EWS quota is only for the general category, right? Meaning poor individuals from SC/ST OBC groups cannot be avail this reservation despite being economically weak, right? Okay, this violence, that violates, and this is totally violates the right to equality. Okay, potential for misuse. The income limit of 8 lakh per year for EWS very high compared to India's per capita income. Right, many people who are not truly poor can falsely claim EWS benefits, right? So here dilutes I mean to say meritocracy. Reservation in general, right, is often criticized for reducing merit-based selection here. Introducing another category of reservation increases the overall percentage of reserved seats, further shrinking opportunities for open competition, right? No clear justification for 10% quota here. The government did not provide clear data or studies, right, justifying why exactly 10% reservation was required for EWS. The percentage seems here arbitrary and politically motivated, right? So the conclusion of the point is EWS reservation is progressive step towards economic justice, but its exclusion of SC/ST obviously lack of historical disadvantage here and the potential misuse make it controversial. While the Supreme Court has upheld it, concern remain about whether economic based reservation is the best, is a totally best way to address poverty instead of reservation. Better education, final aim, a financial aim, I mean to say, and employment opportunities might be more effective in tackling economic inequality. So this is all about EWS, right? So if I convert in Hindi, right? So look, this is the point is that I have in Hindi and English as well, right? If you have any problem in Hindi, you can go with English, right? If you have any problem in English, then you have to go in Hindi, right? So I have both. In both way, I will try to teach, right? Okay. So in Hindi, I will try to address my point of view accordingly, right? क्या आर्थिक रूप से पिछड़े वर्ग EWS हेतु आरक्षण तर्क संगत है? एक टिप्पणी, भारत में आरक्षण परंपरागत रूप से सामाजिक और शैक्षिक पिछड़ेपन के आधार पर दिया जाता है, जो मुख्य रूप से अनुसूचित जाति SC/ST, राइट, SC/ST है और पिछड़ा वर्ग को लाभ प्रदान करता है। लेकिन 2019 में 103वें संविधान संशोधन अधिनियम द्वारा आर्थिक रूप से कमजोर वर्ग EWS के लिए 10% आरक्षण की व्यवस्था की गई है, राइट। यह पहली बार था जब आरक्षण को पूरी तरह से आरक्षित आधार पर दिया गया। यह निर्णय विवादित रहा। इस पर बहस जारी की गई। केवल आर्थिक स्थिति को आरक्षण का आधार बनाया गया, ठीक है। सो EWS आरक्षण के पक्ष में तर्क, तो आर्थिक असमानता को दूर करने का प्रयास। यह उन गरीब लोगों को अवसर देता है जो सामाजिक रूप से पिछड़े नहीं हैं लेकिन आर्थिक रूप से कमजोर हैं। समानता के संवैधानिक आदर्श को बढ़ावा, ठीक है। यह संविधान में दिए गए समानता के अनुसार अनुच्छेद 14 आर्टिकल 14 के अनुरूप है और उन लोगों को अवसर देना है जो पहले आरक्षण से वंचित थे। तो आरक्षण प्रणाली में संतुलन, पहले सामान्य वर्ग के गरीब व्यक्तियों को कोई आरक्षण नहीं मिलता था, जिससे उनके लिए सरकारी नौकरियों और शिक्षक स्थानों में कठिनाई होती थी। ठीक, आरक्षण का सामाजिक कलंक कम करता है, आरक्षण का सामाजिक कलंक कम करता है। तो यहाँ पे चूंकि यह आरक्षण जाति के आधार पर नहीं बल्कि आर्थिक स्थिति के आधार पर दिया गया है, इससे आरक्षण को लेकर नकारात्मक धारणाएं कम हो सकती है। राइट, सर्वोच्च न्यायालय द्वारा मान्यता। सो जनहित अभियान बनाम भारत संघ 2022 में सुप्रीम कोर्ट ने इस आरक्षण को संवैधानिक रूप से वैध करार दिया गया है। राइट, तो ईडब्ल्यूएस आरक्षण के विरोध में तर्क। तो आरक्षण की मूल अवधारणा के विपरीत भारतीय संविधान के आरक्षण का उद्देश्य ऐतिहासिक सामाजिक अन्याय और भेदभाव को समाप्त करना था। आर्थिक स्थिति बदल सकती है, लेकिन सामाजिक पिछड़ापन पीढ़ियों दर पीढ़ी तक बना रहा है। तो बात ऐसा है कि यहाँ पे ST, SC, OBC वर्गों को ईडब्ल्यूएस लाभ से बाहर रखना। ठीक है, तो यहाँ पे ईडब्ल्यूएस आरक्षण सिर्फ सामान्य वर्ग के लिए, यह अन्य कमजोर वर्गों के गरीब लोगों को समान अवसर नहीं देता है, जो समानता के अधिकार अनुच्छेद 14 का उल्लंघन हो रहा है। ठीक है, तो दुरुपयोग का संभावना। ईडब्ल्यूएस की वार्षिक आय सीमा 8 लाख रखी गई है, जो भारत की औसत आय से बहुत अधिक है। ठीक है, तो इससे फर्जी प्रमाण पत्र बनवाकर इसका दुरुपयोग होने की संभावना बढ़ जाती है। तो प्रतियोगिता, तो यहाँ पे प्रतियोगी परीक्षा और मेरिट प्रणाली पर असर। तो यहाँ पे पहले से ही कई श्रेणियों में आरक्षण होने का सामान्य वर्ग के प्रतिभाशाली छात्रों और उम्मीदवारों को सीमित अवसर मिलते हैं। अब ईडब्ल्यूएस कोटा लागू करने से मुक्त प्रतिस्पर्धा, डेट वी कॉल द ओपन कंपटीशन के अवसर और कम हो जाएंगे। ठीक है, तो यहाँ पे 10% कोटा तय करने का कोई ठोस आधार नहीं है। तो सरकार ने यह स्पष्ट नहीं किया है कि 10% आरक्षण क्यों आवश्यक था। यह प्रतिशत मानना और राजनीतिक कारणों से तय किया गया प्रतीत होता है। तो इसका निष्कर्ष क्या है? व्हाट इज द कंक्लूजन ऑफ द पॉइंट? सो हियर ईडब्ल्यूएस आरक्षण आर्थिक न्याय की दिशा में एक महत्वपूर्ण कदम है, लेकिन इसकी सीमाएं और चुनौतियां भी है। ठीक है, यह सामाजिक रूप से पिछड़े वर्गों के गरीब लोगों को बाहर रखता है, जिससे यह पूरी तरह से समावेशी नहीं बन पाता। तो इसके अलावा बेहतर शिक्षा, वित्तीय सहायता और रोजगार के अवसर देना गरीब को दूर करने के लिए आरक्षण से अधिक प्रणाली उपाय हो सकती है। अतः ईडब्ल्यूएस आरक्षण को लागू करने के साथ साथ सरकार को गरीबी उन्मूलन की अन्य नीतियों पर भी ध्यान देना चाहिए। So this is all about the EWS, right? जहाँ पे हमने पॉइंट ऑफ व्यू को रखा है। तो यहाँ पे क्वेश्चन क्या था कि क्या आर्थिक रूप से पिछड़े वर्ग EWS हेतु आरक्षण तर्क संगत है? टिप्पणी कीजिए। क्या था कि क्या आर्थिक रूप से पिछड़े वर्ग हेतु आरक्षण तर्क संगत है? Is reservation for economically weaker section EWS justified? So this is all about. So yeah.